This is an historical day, right? Donald Trump, former president of the United States, was indicted in New York. The arraignment took place today, and I thought it would be interesting to grab some friends of mine, some associates of mine, some acquaintances of mine, and basically talk about what's happened, what's going to be happening moving forward, just to set the stage. If some of you are at work all day and you didn't have a chance to listen to the radio or log online or watch the television, earlier today, former President Trump was charged with 34 felony counts, that's felony counts, of falsifying business records, making him the first former president to face criminal charges. I've listed the indictment and the statement of facts, two separate documents, which for purposes of today's show, if you hear anyone refer to indictment or statement of facts, we're talking about everything put together because that's the way they're read. They're all available for you to read right now. I put them on a page on my blog. If you go to mitchjackson.com/Trump Trump-documents, or you check the comments to this event, you should be able to see the link. You can bring those up while we're talking. If you have any questions about the documents, what it means, what you think may or may not happen, you can definitely refer to those documents when you jump into the show. What's interesting, everyone, and Eric, I'm going to start with you after I do introductions, so I'm going to give you a heads up. But what's interesting is in the indictment, everyone's going to see New York Penal Law, Section 175.10, being referenced, I believe, in each and every count, in each and every criminal charge. And basically what Penal Law 175.10 says is that, quote, a person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree, and when his intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. So there's a reason why that particular code section is set forth in each charge, and we'll have the other lawyers maybe dive a little bit deeper into that. Starting things off today, we have Ira Rothken. Ira is an American high technology attorney and computer scientist who has handled numerous cases of first impression involving the internet and new technologies. He's a friend of mine, and we've done a few shows together. Ira is also lead global defense counsel for Kim.com and his company Mega Upload in what has been called the largest criminal copyright case in U.S. history. So Ira's bringing a lot of experience to the stage. Eric Anderson is a former deputy county counsel for Contra Costa County, a prosecutor, and is now in private practice here in Southern California. He's prosecuted gangs and members of outlaw motorcycle gangs for operating and continuing criminal enterprises. Today, Eric's in private practice defending individuals charged in both misdemeanor and felony proceedings here in the state of California and in federal court. We have Jarrett Abeau, who's a criminal defense attorney out of Louisiana. He's a court-qualified expert in forensic DNA interpretation, and in his 13-plus years of practicing criminal defense, he has brought more than 50 felony jury trials to verdict. So that's a lot of experience in court. Also, Jarrett, thank you for your service. Jarrett served in the U.S. military in Kuwait and Iraq in 2004 with the United States military. So that sets the stage for what we're doing here today. Eric, why don't you start things off? Talk to us a little bit about, and I want to rotate around the panel with just a couple of minutes each. What's your initial impression of, what you saw today of your review of both the indictment and the statement of facts, and leading all the way up to 5 o'clock Pacific time? What's your initial impression, buddy?
All right, well, the first thing that I noticed was, what are the new facts? I mean, what is it that wasn't known 5 to 7 years ago that we know now? And I'm not so sure that there's anything all that much new that was already known to the prosecution back then. What I found interesting was how specific they're getting in regards to, when you see 175.10, and if there's anybody out here who practices in New York, I'll defer to your expertise. One of my first thoughts, okay, what's the crime that they're trying to cover up? And I think one of them clearly here is the 175.05, which I just learned about today, and that is the falsifying of business records. Because when you look at the statement of facts, it's clear for some strange reason that there was always this attempt to put in, with the Trump Organization records and these other entities, each of these payouts. And my initial thought would be, why in the world did they do that? So I can only figure that these documents at some point have either been relied upon by the Trump Organization in filling out other documents that have been submitted, particularly for tax purposes and other purposes, and that's where part of the crime takes place. Other than that, your first thought would be it's just a payoff, but it's the sheer audacity of, as far as what's been alleged and what we know so far, of the idea from the beginning was we have to cover up the whole thing, even though it's a serious question as to whether the initial payout would have even been a crime, because I don't think it would have been.
Well, I've read that paying hush money, both at the state and federal level, isn't in and of itself a crime. And so I'm glad you brought that up. But when you looked at the allegations that were brought today, where allegations of conspiracy at both the state and federal level, resulting in these 34 felonies being brought, it's all come to fruition that has brought us to what we observe today. And I know Ira's played in this arena a little bit, defending clients, handling lead counsel on large class action cases, both at the state and federal level. Ira, what are your thoughts? What is your first impression with what you've read and what you've observed during today's hearing? And also, what we're doing today, everybody, is we want to encourage live Q&A. Give us 10 or 15 minutes to set the stage before we start inviting people up. But we're also trying to do this objectively, okay? We're trying to put politics aside as much as possible. We all know politics is a factor in everything that we talk about today. But from a legal standpoint, Ira, what's your impression as to what you saw and read regarding today's proceedings?
Thanks, Mitch. All right, first of all, I'm totally apolitical. I mean, to the extent that I could actually analyze myself. I did Chat GPT to ask Chat GPT, when am I? And it actually said I'm right in the middle. Okay. So, I mean, look, I did litigation for EFF. I use liberal progressive principles in defending criminal defendants. I believe in due process. And in many ways, and it's ironic, many of these liberal principles of due process and predictability, I'm having a problem with, at least initially, in looking at the indictment. So I'll give you the distillation of my initial thoughts. First of all, for those who are not lawyers, we're going to be seeing this term federal preemption all over the place. Federal preemption means when Congress goes ahead and passes a law, for example, FECA, which is the Federal, Campaign Act. That act was created in the 70s. It was modified along the way. They have express preemption in there. So it has to do with, keeping track of things that are related to campaign finance on the federal level, receipts, things of that nature, all preempted. It's express preemption. And New York's highest court has embraced that and agreed with that. So we start with that, and then I look through the indictment, and let's face it, I mean, it's a New York State indictment, not federal. They're the government. They have a duty of good faith and candor. They're supposed to be the model litigants. And you look through there, and you have a whole bunch of what should be misdemeanors with a 2-year statute of limitations, with a penal code in New York. And they're trying to go ahead and use, implicitly, I'm guessing, the federal law, which has a 5-year statute of limitations, and it wasn't brought on the federal level. And so now when you're trying to do that in New York, the question is New York the right jurisdiction for litigating, at least as a part of this case, something that's preempted completely and expressly under federal law? Without that, there'd be no felonies. You'd have a 2-year statute of limitations. They'd all be misdemeanors. And if that's allowed to happen, then they're bypassing what is the federal statute of limitations of 5 years if it was brought under federal law. So I'm looking at this in a liberal sense by basically saying this sort of puts up my antenna on whether or not this was politically motivated, if this was fairly brought, and if Trump does succeed on federal preemption, it's going to be like a bunch of dominoes, and this case is going to go right into the tank. So that's where I start.
Interesting.
Yeah, Ira, did you have the same thought as in when you read it? Your first thought was, "What's new?" Because if I think something new, then I would have thought, "Oh, okay, well now I know what's coming." But by the end, I couldn't see anything that we didn't already know.
Let me tell you what I thought was really astonishing. What wasn't in there? When I look through an indictment, and I've had this in multiple cases, even in federal court, when I look through the indictment, what wasn't there? Well, what's the predicate that's making this into a felony? Yeah. We're all assuming it's going to be the Federal Campaign Act, but they don't overtly state it. They state no felony statute. Now, I would have to say that normally what you would see in an indictment, the way that I'm used to seeing them, and it's really easy to survive a motion to dismiss on an indictment versus civil law, which you think would be the opposite, but it's not. You just got to lay out what the basic facts are, then lay out the elements of the crime and just say that somehow this person committed those elements. But I don't see any elements of a federal crime in there that are the predicates for making this thing into a felony. They couldn't even say what the elements are. If they want to use New York's similar statutes to federal campaign finance crimes, well, they could have said that. I would say they probably have an obligation to say that. Some people would disagree with that, but they don't say it. And so I'm looking at this, I'm saying, do these guys just want to win? Or do they want to do justice as a model litigant? A model litigant would lay it out, and they would say why they're allowed to say that and why it's not preempted by federal law. They wouldn't just be playing a game of litigation, just trying to win. So that's what I saw.
Let me jump right back in here because I want to bring Jarrett into the conversation. Just a couple of things. One of the things that we're looking at, and I read through the indictment carefully and the statement of facts, and I've been listening to commentary on some of the different channels that I'm paying attention to, is the federal law is not going to have anything to do with this case, Ira. It's interesting. What they're doing is they're charging that particular penal law, they call it penal law section 175.10 in each charge, which basically talks about falsifying business records in the first degree, okay? If that takes place in violation of that penal law, 175.10, to further either state or federal election purposes, for example, to keep something quiet so that somebody can get elected, federal law is not going to come into this particular state prosecution. And I think that Bragg and his office are a little bit more crafty than we're giving them credit for as far as keeping this in a state venue. Having said that, the non-specific portion of the indictment, and Jarrett, I want you to talk a little bit about this. There's going to be, as all of you know, a motion for a bill of particulars. Okay. Yeah. And so Jarrett, maybe talk to us a little bit about your first impression. Do you agree with what everyone's saying? And what's a bill of particular and how will that come into play to maybe clarify some of the, I hear Ira in the background. Jump in, buddy.
Yeah, well,
I had the same reaction. Ira did.
Mitch, I love you, but I got to jump in when I disagree.
Absolutely.
Yeah, I'll correct him, Ira, if you want me to. I'll be happy to let him know where he was off there.
I'll give my one sentence and then you expand on it. And that is that he's using the New York state law, and then he's using as a predicate to make it into a felony, a part of the New York state law, which is then reliant upon another crime. And the crime that's that predicate is the federal crime or a New York state analog, which may be preempted. And then I will now hand it off to Jarrett to discuss that further.
Love it.
Yeah, and I agree with Ira. I mean, that was my first impression as well. This is falsifying business records of the second degree, which is just a misdemeanor in the state of New York, as I understand, which is 175.05.
Yeah.
Unless there is a separate intent to conceal another crime. And I think that's exactly what Ira was talking about. What is that other crime? Well, it's not clear in the penal statute. And look, I'm a Louisiana lawyer, but as I read the New York penal statute, it's not clear in the penal statute what that means. Is it another misdemeanor? Is it another felony? Is it a state crime? Is it a federal crime? It's very unclear. It just says pretty broadly another crime. And so is it possible to use the federal crime as the predicate for raising this from 175.05 to 175.10. In other words, can you use the federal crime as the other crime with the separate intent to conceal? And that's, I mean, that's a question maybe for a New York lawyer, but I think that was my first impression too, Ira, was, well, where's the other crime? Why wouldn't you put the other crime in the indictment? Because, as Mitch said, I'd immediately find a motion for a bill of particulars, and I would say, in what particular, a bill of particulars is basically a document that says, all right, Mr. and Mrs. DA, tell me the particulars of the facts that you have that you think you can prove in order to meet the elements of the crime here, which include naming the other crime. Like, what is the other crime? Because this penal statute requires a separate intent. It's very clear that it's an intent to file fraudulent business records with the intent to conceal another crime or to commit another crime. And so to me, those are two separate intent questions. And so you would have to have not only the intent to file the fraudulent business record, but also the intent to conceal the other crime. In other words, knowing. And I think, if I may, other initial impression was, I think Donald Trump's biggest issues here are the 8 payments made to Michael Cohen. Those other checks, the other matters, the other sort of accounting matters. I mean, this is a massive company with massive layers of managers and massive, persons along the way doing things that Donald Trump never would sign his name to or to understand what was going on. And so to have, to think somehow he knew that some payment was being made to the My Pillow guy or the MCI, whatever that media company is that was, concealing the second prostitute or second sex worker that he had sex with. It's those payments to Cohn, because he's so close to Michael Cohen and they have such a everyday kind of relationship that it's the kind of thing where, now that Cohen has been convicted of the federal crime, which might be the other crime necessary for this to be a felony, now that Cohen's convicted of that, and he's obviously, as a part of that plea agreement, agreed with the federal government to testify truthfully in any further proceeding, be it for felony or state. He can get in trouble for not doing so. In fact, he can lose his plea for not doing so. He's going to come in and say, I talk to Trump every day about getting my $131,000 back. And every time he wrote me a check, I said, thanks for paying me part of that $131,000 back. So Trump knew, should have, and they may be able to prove knew every day, every time those payments were made, every time those 8 payments were made. And that, to me, is the big red flag for Trump, which is the intent. He then has the criminal intent to have covered up that other crime, and the criminal intent to have fraudulently known, or at least known, that there was an intent to fraudulently file the business records. I think that's his biggest problem with those 8 counts. I don't know. I'm a little iffy on the other 26, honestly, as I read them today. But I think that's his bugaboo.
What's interesting, real quick, because I want the three of you, because you do a lot of criminal defense. What is the importance of a bill of particular? For example, let the audience know, for example, Jarrett, you have these questions. In other words, what is this underlying crime? In other words, Bragg did mention something about tax returns today. He mentioned taxes in one of the charges during his press conference. The purpose of the bill of particulars, why is it so important right now? Because when the prosecution responds to your motion or request for bill of particulars, they're going to have to lay out in more detail, if I'm correct, Jarrett, as exactly what that underlying crime is going to be. Isn't that true?
Yes, and I believe that to be the case in most states. I'm not sure about exactly in New York, but it locks the prosecutor into, if the prosecutor says it's the Federal Elections Act crime that we're using as the quote unquote other crime to make this a felony, and again, I'm assuming that they can do that. I'm assuming it doesn't have to be state law. Then he's locked in on that. So if you have to go to trial on it, and you put it to a jury, you have to prove to them that crime was committed. Now you can, because Michael Cohen pled guilty to it. But you understand I think your point, Mitch, is that the bill of particulars locks the district attorney into a set of facts that they have to then prove. It's sort of the pieces of the elements that the district attorney says they have. And they can't sort of pull something out of the hat in the middle of a trial and say, oops, well, we couldn't prove that crime, but we're going to prove this other crime. In many states, and again, I'm not sure about New York, but in many states, that those things would be excluded as being able to be proved, because the defendant has a right to be on constitutional notice of the crimes for which he's facing, or the facts from which support the prosecution. So.
Gotcha. And Ira and Eric, feel free to step in. And so that's why, as of 5:24 Pacific time on Tuesday evening, just because we don't know what that secondary crime is doesn't mean it's not out there. The way this indictment was pled, accompanied by the statement of facts, my understanding that's fairly normal for the state of New York. I practice here in Southern California. Ira practices around the country, also in California. Eric's California, Jarrett's in Louisiana. And so I think there's a lot more to come, but I think there's also a tactical play to using that type of indictment. You're not painting yourself in a corner when it comes to, what direction you're going to be taking these charges. Although to Ira and Eric's point of view or perspective, these charges, there's nothing really new in this indictment. To answer Ira and Eric's question, why is this taking so long? Do either one of you feel that with former President Trump being in office, whether or not that stayed the district attorney's decision to move forward, or maybe the prior district attorney for the Manhattan office, he was told to stand down by the Southeastern District. I mean, these are all things that come into play. I did note while Jarrett was talking, the statute of limitations in New York is 2 years on a misdemeanor, 5 years on a felony. So that would be New York law on the 5-year statute. But Eric, I mean, what would be...
Do you think there's a distinction?
Go ahead.
Do you think there's a distinction between other crime and other prosecutable crime? In other words, does the crime still have to be prosecutable in order to be used as the predicate? I'm curious about that, actually. I thought I was going to ask Ira that question.
But, yeah, I think that is going to get interesting, because one of my concerns when you asked that question was, we already know about the now infamous DOJ memo that says you can't indict a sitting president, which I'll argue till the day I die has no constitutional muster behind it whatsoever. But there is no such thing anywhere that says a state can't do it. So I would, frankly, I'm a little bothered by, and I'll be honest, I am not a Trump fan at all. Never have been, never will be. I'd rather give away parts of my body than ever vote for Donald Trump. But fair is fair. And I think one of the issues here is, if it has taken so long and we don't have new information, and this is information that was well known to them years ago, then there should be somewhere a decent answer as to what took so long. So that's one of the things that I think is also going to be part of the defense, would probably be a statute of limitations argument, that, look, there was nothing stopping you from trying, and you didn't. So now your time's expired, leave them alone.
Well, all right. So let me argue the other side, to be fair.
Sure.
Just for a second on that issue. There are pretty draconian rules on the statute of limitations out of New York and other states that do not count the time that you're out of state. And Trump, maybe was back in New York for like 80 days since a long time ago.
Great point.
So, somebody could argue that point, especially since he's become a resident, or is attempting to become a resident of Florida. So under that theory, if embraced, and again, you're going to have arguments both ways on this, then maybe even the 2-year statute of limitations hasn't even run if you start getting super draconian. But what feels unseemly is that there is a 5-year statute of limitations under the the Federal Election Campaign Act, and that ran, and so now that's being used. And look, we're looking at the statement of facts. We're going to surmise that's being used as the predicate, additional cover-up that the business records were trying to cover up to get it to a felony. But even if it's not, they're probably going to be using or arguing to use New York's own version of that. And that's still going to be vulnerable to a federal preemption argument. They're both going to have the arguments. One will be, you can't use this federal law as a predicate when it's not prosecutable. And two, you can't use the New York version of it as a predicate when it's preempted. And so this is going to begin and end in a large part with federal preemption. Now, you might ask, from a policy perspective, well, why? Well, why should we go ahead and allow for federal preemption? And now you start getting into these arguments. You have somebody who arguably ran on getting Trump being literally the person who's prosecuting Trump. You have the delay until the eve of folks starting to run for president again, including Trump, where they bring it. You have the feds literally not wanting to prosecute Trump, analyzing it, not prosecuting him for the predicate statute that the state attorneys are using. And then you have a scenario where this is the first time this has happened to a former president. And when you look at the MSNBC versus Fox stuff that's going on, it's unseemly. They each seem to have this point of view that if they could each out-propaganda the other one, we could litigate our way to changing people's minds. And they're fearful of each other station doing that to constituents. Well, could you imagine now if states can go ahead and prosecute in Florida or Texas foot faults against Biden? And now all of a sudden you get past MSNBC versus Fox and you get into balkanized local state laws that could be used for political tactics. So then you'd say, do we really want to allow for that? But we have an answer to that. Seek the sanctuary of federal preemption where you don't leave it up to local states regarding federal campaigns, where you have federal judges who don't get voted out of office if the local constituency in the state doesn't like an outcome like state judges do. They're appointed for life. While you could still have erratic stuff going on, this gets rid of a lot of the unseemly behavior. And so for me, federal preemption is not only grounded in congressional intent, there's really good policy reasons for implementing it in this instance.
Ira, I love the points that you brought. You know, when we talk about unseemly behavior, I look no further than the particular defendant that was charged today. It's that, for me personally, just so everyone knows where we stand, I'm just, I'm appalled by his behavior and by how he's conducted himself. Having said that, that's not evidence in a court of law. The statements that you just made are your thoughts and opinions, and if they were finalized with a question mark behind each one, I would agree with you, but I would like to respectfully just say there are a lot of unknowns as to why, whether or not Bill Barr's office gave instructions to the Southeastern District to instruct the Manhattan DA to stand down, and that's why it wasn't prosecuted. Was the investigation ongoing? Is that why it wasn't prosecuted? The statute of limitation issues, there are code sections that I could cite, but I'm not going to, are legitimate issues for motions that we're going to see a lot of trees, go down in all the paperwork on the motions here. And what I want to do, though, is invite everyone, jump up if you have questions, raise your hand, I'll bring you up. But Jarrett, Ira, and Eric, moving forward, okay, with all of these issues pending, moving forward, I think I heard the judge, I read someplace where the judge said that he's going to require Trump to return to court in December. He was ordered to appear. That could obviously all change with everything that's going on. But moving forward as lawyers, what do you guys expect to see as far as motions, as far as hearings that are going to be taking place? Eric, what would you be doing right now with respect to moving forward because this case has been filed? It's not going anywhere unless it gets dismissed or unless something else happens. What happens next moving forward over the next, 6 to 8 months?
Well, are you asking me as a former prosecutor or as a defense attorney?
Ooh, I'll tell you what, because I know you were a prosecutor, I'd love to hear your take as a prosecutor because, Jarrett and Ira will definitely be able to bring in the defense perspective, but whatever you're comfortable with.
Yeah, I always had a rule when I was a prosecutor that I did not discuss cases publicly while they were active. Until there was a resolution, I wouldn't do it. And my reasoning for that was always twofold. One is I didn't want to get into the publicity aspect. I didn't want to look as if I was trying to get in the public eye. I don't think that's going to happen here. I think there's going to be plenty of people who are going to be talking. You've got a DA's office that, again, this is regular for New York, is going to, consistently do press conferences. You have a defendant who is certainly not going to keep quiet at all. So there's going to be a lot of that barking back and forth, I think, that'll take place. But I think that hopefully if you're the prosecution, at the very least when you brought this forward, you almost got to follow the old rule that we learned from The Wire, right? If you come at the king, you best not miss. You best believe you have all your ducks in a row to at least prove your elements. And if you're going to lose, the only thing you should be losing on, or at least you should have any questions about whether you lose on, are going to be the preemption issue and the statute of limitations. As for the elements themselves, you got to be extremely confident, and that's what they should have been shored up coming forward. As far as the motions go, I think you're right. There's going to be a lot of going back and forth on the details. I mean, look, you had three criminal attorneys who looked at the indictment, and by the end, we didn't know what the second charge was. That's why I automatically went to the 175.05, because the only thing I saw that could be close. We need to remember the other offense could be literally 34 different secondary offenses. It doesn't have to be one or two. So, yeah, I think that's what we're going to start to see. We'll see a little play in public. I appreciate Ira's concern. I especially make it a rule. I don't watch those particular newscasts. I try to stay out of it when it comes to these legal questions because I like to see cases tried in court. But I think we all know we're in territory we've never seen before. So I think we're going to get a lot of noise.
And that's why we're doing this. This is brand new territory. Yeah. And Jarrett and Ira, moving forward, what would be the motions you'd bring? What do you expect to see happen next over the next 6 to 8 months? And then, Bob, I'm going to swing over to you for the first question.
Well, I think Ira's insight into the statute of limitations is very, very sharp. And I would attack the predicate instantly, right? At first, identify the predicate and then attack the predicate in whatever way I could, right? Even if the predicate offense hasn't been charged, attack the statute of limitations. And then the bill of particulars is fabulous because you begin this granular analysis of every single charge. So build each charge. Look, I mean, the big lie out there, right? The big bullshit out there from young criminal defense attorneys is that I don't have to make a case. I just have to tear up the state's case or the federal case. And that's bullshit. You go out and you start to build your defense theory and you do it instantly. You begin to analyze each of these counts granularly, figuring out exactly the steps that went into it and who was in charge of it and how many layers there were between Donald Trump and these transactions, because I think that's the real defense. And you begin to build that defense theory, I think, over the next 6 months, sort of building up from how complex these transactions were and how far removed Trump was from them. That would be where I'd start.
Oh, I love that. And Ira, you've handled cases all over the world. Where would you start on this file?
I incorporate by reference the great points made by our colleagues here. All right. First thing I would look at right here, which is rarely discussed, and these are just issues I'd be thinking about. I have no idea how I would resolve them right now. But I would start with what exactly is the underlying falsification. And right now, I went and looked at the actual confidentiality agreement that Cohen negotiated. And that agreement has in it all sorts of confidentiality and the purchasing of copyrights and all sorts of things. The agreement itself even makes knowledge of the agreement or putting the public on notice of the agreement to be a violation of the confidentiality provision. And so now I throw my hands up in the air. And yes, I've handled lots of giant litigations with e-discovery. Anecdotally, about a quarter of all the business records I look at could be arguably inaccurate. Doesn't mean they're crimes. You have to have mens rea, right? You have this lawyer who's supposed to look out for Donald Trump's best interest and legal compliance doing this thing, maybe even on his own. We'll see. He puts in there that the agreement itself is confidential. And then payment to Cohen, because he pays the money himself. That's listed as a legal expense. That's what the facts say. It's a legal expense. So now I start looking at that and I'm saying, well, that's actually what happened. Cohen paid this. They wanted to keep it confidential. You're not going to go ahead in your business records and write down secret agreement with former porn star that's supposed to be confidential. No, maybe you'd redact it. Maybe you write something for code. So putting in legal expenses to me is plausible. And maybe the argument is that if it's any rational explanation for it, it's good enough. I don't know. But I'd be researching the law on how far afield from accuracy you have to be to pass muster in the statute. I'd be looking to see, Are you even allowed to put in your business records when it's supposed to be confidential, the details, and how that's supposed to be handled in friction with whatever the statute is? And then I'd also be looking at, hey, wait a second. If they don't put into the indictment the part where the grand jury signs this thing, saying that they agree to the indictment, if they don't put in there the predicate elements, I want to know, was the grand jury properly instructed? I mean, obviously a bill of particulars will help, but do we have a moving target where the grand jury itself wasn't even properly instructed? And then finally, I'd be looking at rules of evidence. Going to super smart people, usually new law school grads on law review, and saying, to what extent can we get admissibility when you have the feds passing on this? If we can get any evidence that the feds think it may not be prosecutable, how is Donald Trump as a layperson supposed to develop the mens rea for violating this federal law when federal prosecutors at worst disagree on whether or not it's a violation? So those are some of the areas I'd look at.
Ira, wasn't Trump individual one in the early proposed indictment that never went forward?
I don't know. Somebody would have to look
Yeah,
at it.
yeah,
that's been the assertion. That's been the assertion.
Yeah,
but
I think
I don't think that's ever been public.
Well, actually, I think it's my understanding is that he was, and there were other reasons why they didn't go forward. But with Cohn pleading guilty, it's interesting. It's a paper trail. It's a documented type of case, and so for me, I was looking at what type of impact is needed by Michael Cohn, who pled guilty, did his time. Now he's coming back. What do you believe? What he said back then, or what he said now? But what I'm looking at is crossing the T's and dotting the I's on the paper trail. I actually feel, Ira, I understand where you're coming from. I think that is the argument that the other side's going to be making over the next few months, in addition to the statute of limitation arguments. But it's going to come down to, I guess, the trier of fact. We'll see what a jury decides. Now, that indictment is a proper indictment. It's not a thin indictment. It's not a incomplete indictment. It's a standard indictment in the state of New York, and that's why they use bill of particulars to get up to speed on all the details. So we'll see what comes out of that. But let me jump down to the audience members. And Bob is an old friend of mine, helped me get my first pair of Google Glass. And Bob, Ira was a early user of Google Glass back in the day. It's good to see you, my friend. It's been way too long.
Yeah, Mitch, thanks so much for doing this. I would not have missed this for the world. And thanks, guys, for joining and offering opinion. For what it's worth, I live in Atlanta, so you can probably guess where this question is going. The New York case, I can't really work out. I mean, I've listened to you guys over the last 40 minutes. Can't work out if there's a real case here or not. The Georgia case, though, man, that just feels like, 50 ways come Sunday between the phone call, the fake elector scheme, everything that's taken place in Georgia from what we know really points to a much more difficult situation for Trump and a defense. I'd love to get, first of all, your guys' takes on it based on what you've seen and heard. Now, I know we can only go by kind of what's out there in the mainstream at the moment. But then the other question I was going to ask you, which is just stuff you generally read about the fact that it seems like a lot of people were really hoping Bragg would not push this as the first case forward and would have led either with Fannie Willis or with Jack Smith. And I think Jack Smith's work's probably a lot further away from being ready, but the Georgia case certainly seems a hell of a lot closer. And what do you think at this point is holding it from moving forward and hearing more about it? Thanks again, guys. Appreciate it.
Yeah, Bob, stay on stage so you can ask a follow-up. Just a real quick context, and I'm going to let everybody else jump in on the particulars. But, in the Georgia case, Trump's facing potential charges in the state of Georgia for allegedly attempting to overturn the 2020 election results. And Fulton County District Attorney, Fannie Willis is handling that. The special jury recommended multiple indictments. According to the jury's forewoman, a redacted report shows the special grand jury also believes several witnesses lied under oath. As Bob alluded to, then we also have the Justice Department investigation into the efforts to overturn the 2020 election. And then we also have the classified documents case with Jack Smith, looking into, what's been in the news. So there's a lot going on. Without getting too sidetracked, gentlemen, with respect to Bob's question, thoughts regarding this case being filed first? What impact, if any, do you think it will have on either the investigation or prosecution on these remaining potential criminal cases? Jump in.
Having tried a couple of federal tax crimes, I'll tell you that, Bob, that the transaction crimes are oftentimes much easier to prove because transaction crimes are general intent crimes. So what that means is that you have to prove that the person had the intent to cause the transaction, but not necessarily that they had the intent to commit the crime. If you can show that they had the intent to cause the transaction, and that transaction is criminal, then they're guilty of the criminal offense by general intent instead of specific intent. That statement, "Hey, will you find me 11,000 votes?" can be misconstrued or misinterpreted or interpreted as him just saying, "Man, find me 11,000 votes, boy. I hope we can recount and get legitimate 11,000 votes, right?" And so, I don't know a lot of the specifics of Georgia, but I'll tell you that transactions crimes are unbelievably difficult to defend, and so I think that this transaction crime that's they're bringing in New York's pretty powerful. That's my initial impression.
Yeah, I'd have to share that thought with Jarrett. The other thing too is, we're not really all that accustomed. I mean, maybe my other colleagues would disagree, to watching state and counties move slow on prosecutions. They tend to move, pretty quickly compared to the feds. I mean, often by the time the feds come a call in, they know exactly what you've done and are waiting to see if you're going to lie about it. So I really can't explain as to why it's taking so long for any of them, except, of course, for the obvious, which is you have a very high-profile, wealthy defendant. You are going to have a nightmare in trying to put together a impartial jury. You're going to have a media mess every time you get involved. So I can see where there would be a great deal of caution here. I think that Jared's right. One of the things about the paper cases is there's paper. So, you're not just relying on just what Michael Cohen says. Now you're also relying upon what others say and the documents that support what they say, or at least can be interpreted as supporting what they say. So I think that's one reason why eventually Bragg decided to do it. As to why everybody else is moving slower, again, I think they just want to walk in with as much ammunition ready to go, because once it's on, it's not going to be pretty.
You can also subvert intent with in the federal law, and I believe in New York too, if I'm not mistaken, there's a provision in the law called deliberate indifference, which the prosecutors can use to get around the intent part of it, and it is pretty freaking nasty for a defendant to defend himself. So again, transaction crimes are very, very difficult for so many reasons to defend, but it's a slog.
Ira, any input?
No, I'm not going to have any input on this one, because I want to wait to see if there's any indictment and then sort of look at what the fact pattern is right there.
Yeah.
And I haven't really fully examined the media reports on these things, so I don't really have much to add.
It'll be interesting to see what happens. Speaking of intent, I did print out something, and it talks about proving intent in a criminal case in the state of New York. And what it says here is applying the broad concept of intent to defraud in false business record cases. New York state courts have found such intent in a wide range of cases, including when a defendant made a covert contribution to a political campaign, covered up an alleged rape, misled the relatives of a patient about the individual's treatment, operated a motor vehicle without a license, obtained credit cards through false documents, but with no proof of intention to miss payments, frustrated the regulatory authorities of the New York City Transit Authority, and many, many more examples. The point of this particular post was it's a very broad type of intent that a low bar to proving this type of intent in the state of New York in these types of criminal cases, which probably doesn't favor any defendant that's being charged, but only time will tell. Bob, yeah, it's interesting. I actually was a little bit curious as to why this was the first hammer to drop myself. And I think one thing we didn't talk about is Trump was in office until 2020, right? And so prosecuting a sitting president. I think that was put on hold. So we're looking at, January 20 through the present. That's why things are happening right now. It seems to me, though, that Jack Smith is he's really moving that federal case along, Eric. I mean, Jack is just pushing this thing along. I mean, it seems to me like he's crossing his T's and dotting his I's for good or bad. So we'll see what happens. Bob, what are you up to right now? Where can we connect with you if we want to stay in touch?
Working at MasterCard, man. So here protecting your transactions on a daily basis. So hopefully we're doing a good job. Just drop us a note, Mitch.
All right.
First out, last at MasterCard.
All right, I will do. Yeah, when I met Bob, he was heading up technology at Thomson Reuters. So it's good to see you, Bob. It's been way too long.
Thanks again, man.
All right, Bez, microphone is on. Unmute and jump in, my friend.
Hey, this is a great conversation. And just to put it in context, I'm in the same state as Bob. Recently moved back to Georgia after being, left the state in as a teenager. So I'm back 2 years ago, and it's interesting moving from California. I left it as a teenager, really not, didn't care what was your political affiliation, but coming back here, Ira mentioned something about referring the case and the venue. And so the reason I'm up here is because of that Trump case about the overturned the election here in Georgia. But I'm more worried right now about there's Senate Bill 92 that's been passed here in the Georgia State Senate. And it's now, it went to the House. I don't know where it's at in the House, but it's basically creates a commission that they could remove the DA or prosecutor at will if they don't like who you're prosecuting. And it's a lot of people are looking at this as, hey, a setup to take out the DA who's prosecuting Trump for the shenanigans going on with the election down here. What are your thoughts on that? I'm just a little bit, I don't know where my head is, but I'm a little bit petrified about what's going on. What are your thoughts, and how does that impact other states or future things that may happen across the U.S. here?
Jump in, anyone. What do you guys think about that?
Almost nothing a former Confederate state does surprises me.
Tell us how you really feel, Eric. No, seriously.
Hey now.
Hey, listen. My
I'm
wife.
sorry, but
My wife, my partner, since day one here at the practice, she's really concerned about that too, Bez. Eric, I'd love to hear your objective feedback on, what do you think when we have politicians, whether it's at the state level, like in Georgia right now, or, you could look at the Jim Jordan's letters to the Manhattan DA Bragg about, you could look at that as, interfering with the prosecution. Thoughts, Eric?
Frankly, part of it is I blame the public. And of course, not all the public, but politicians will often do things to get a reaction from the public because they think it's what certain members of the public, particularly their base, want. So they will do these things. It's along the lines of, oh, what's that? Well, my base will be very happy if I turn around and now go on the attack against this company that has a problem with the policies I've issued. And so let me take an action which has no real legal justification for it, and let's do it to retaliate. Let's do what we can to remove power. We've seen it in several states before. If we go back far enough, each party has participated in this at some point in their history of, there's someone new coming in. Let me strip all the power of the office before they get in there. Let me give my guy or my gal the ability to go ahead and do an end run around every other rule that's been there. It happens a lot. It's just right now it happens to be the turn of, as you said, where we're seeing it a lot out of coming in the old Confederacy. It's right after the same kind of playbook they ran, after Reconstruction. It's just a playbook that's been used repeatedly, and others will use it. It's always bad, but it will happen so long as you have a populace or constituency that says it's okay. When they're not fine with it, then it stops. When they are fine with it, it doesn't.
So could they remove the DA who's prosecuting Trump for these crimes before it actually, goes to court? Or is it too late for that? Or what's at jeopardy here with this law in play?
Well, it could be. Admittedly, I only follow some of what happens in Georgia. And I haven't read the statute, but I've seen other attempts for statutes like that across the country. So yeah, you absolutely could have that happen. Now, again, you could also have a judge who, depending upon how it's done, because remember, rules matter, who could turn around and say, no, you can't do this because of the way you did it. Because that's another thing we've seen. We've seen a lot of people who've come up with a variety of rules to disempower somebody, and then they find out that they did it the wrong way. So it's worth keeping their eye on, but it's one of the reasons why I don't live in those places.
So let me ask a question on a broader scope. When we do look at the Speaker of the House, Jordan, sending letters, his committee sending letters to the DA, Bragg, and in the state of New York, at what point, Ira and Jarrett, and then Eric, you can jump in if you want, at what point, if any, does that become an obstruction of justice? Does that become an interference of the state prosecution of a potential crime? Or are you both completely okay with that type of federal communication to a state prosecutor? I'm curious. Don't be shy.
I mean, I find it. Yeah, I find it. It's distasteful. I think. I mean, Jim Jordan has a right to say and do whatever the shit he wants, right? I mean, he's got a sort of right to say what he feels like he says and disagree with people he feels like he disagrees with. And I don't have any issue other than the fact that I find it politically distasteful, and I find it, I find this whole idea, like the thing today, someone, I think Eric Trump posted a picture of the judge's daughter, and that she somehow had, given to the Biden campaign, and that he was somehow biased over that. And I guess some people are free to do that. I would say this: if any one of the people that did that was a licensed attorney, he'd face some pretty serious problems with the disciplinary council of his state that he was barred in. So, I mean, I know we're held to a higher standard, a higher ethical standard as lawyers, but it bothers me. But I, in the end of the day, I don't think we can. I believe in a vigorous political debate, and I think that a vigorous political debate is the best thing for our country. And I know it gets ugly sometimes, but if we start quieting that, I think we're going down a very, very shaky road.
If it got to the point where a prosecutor was subpoenaed to appear, in front of Congress, though, to frankly answer a bunch of bullshit questions, I mean, at what point, Ira, would that constitute, an interference with a state prosecution, or would it not? I mean, I don't know. I'm curious.
I haven't done the legal analysis on how far Congress can go using their ability to investigate, their investigation power. I mean, again, this likely touches on federal election law, and so you may have an overlap. But I find, one of the things that I think is fair here is that I'm not a Democrat or Republican, but I would say the same exact things if someone in a Republican state was doing the same thing to a Democrat. I'm just concerned about that, to be honest with you. And so for me, I find this to be the weaponization of state crimes against federal elections. And I'm deeply concerned about that. If somebody violates state law, so be it. But this begins and ends, in my view, currently, until I could see otherwise, with a federal campaign for president and trying to figure out how to bypass the federal statute of limitations. And it's happening on the eve of running for president. And if the roles were reversed, and this was a Democrat who was the target, I'd be equally upset. And so maybe one day we'll have another one of these shows, and I'll be on making the same arguments for a Democrat as I am for a Republican.
Absolutely. No, amen. That's why we're doing this today is we're just dealing with the facts of this particular case. And I'm curious, once we learn more, once there's a bill of particulars that's responded to, we know exactly what all the charges are, what all the contentions are on both sides of the coin. Maybe we can have another show in a couple of months and kind of revisit some of these issues. Wrapping things up today, starting with Jarrett, rolling over to Ira, ending with Eric. Would the three of you just share with me and the audience, what would you like to see happen next in this particular case? In other words, in order for there to be, for the justice system to work moving forward, what would you like to see happen next, in a minute or less, to help, solidify the foundation of, due process, equal protection, the preservation of state rights and federal rights? Like, what would you like to see happen? Whether it's the ascertainment of facts, whether it's how hearings and motions are being held on this particular case. What's going to happen next, Jarrett? And then I'm moving over to you, Ira, and we'll wrap it up with Eric.
Thank you, Mitch, by the way, for putting this together. It's been a real pleasure, and I'm honored to have been on the stage with all three of you guys. In fact, all five of you. I'm just an old boy from down the bayou in Louisiana, man. I'm a frontline criminal defense attorney, fighting prosecutors every day and practicing criminal defense in a very small scale. And so I appreciate you bringing me here. You know what, man? I think transparency is the big deal, Mitch. For me, for the health of our country, for the people here, for us to see that this thing works, that this criminal justice system works, and that no one is actually above the law. I think that we need transparency, and I think we need to set aside our personal feelings. I mean, I couldn't be more disgusted. I'm a Second Amendment believing combat veteran liberal Democrat in Louisiana, and Donald Trump couldn't disgust me more. And I think he deserves every protection in the law. He deserves every benefit of the doubt. And I think that this thing needs to be done right and transparent. That's really my thought is, let's not screw this up and do this in a way that's unfair. Let's let people see that the criminal justice system works.
I suppose I agree with everything that Jarrett said. And, there's not too much disagreement on this stage, which in itself may be troubling for everyone. But I could understand why the New York State prosecutors are bringing this. I think that the outcome, based upon the four corners of the current indictment and statement of facts, may very well be that this is preempted by the Federal Election Campaign Act. And I think that from a legal and policy perspective, that would be really good. It would help normalize the law so that you won't have, each state now having to do retaliation and tactical prosecutions and bringing chaos to the national fabric. And I think that would be a really great result. And frankly, it would protect Democrats and Republicans alike. So, that's where I hope it goes. I don't like the unseemly use of a misdemeanor to be elevated using federal campaign laws by a local state prosecutor in an adverse political state, against the former president, no matter which direction it goes. So that's kind of my distillation.
The first thing I'd like to see is I'd like to see a lot less shaming of Stormy Daniels. I've noticed that they thought it was very important to mention she's a porn star, and as someone who represents sex workers, I'm getting a little tired of them being treated as far as these great pariahs. So that I'd like to see ended. Along with that as well, like Jarrett, don't worry about being a boy from the bayou. I'm the son of a woman from Gibson, Louisiana. So I'll joke about the Confederacy, but I also can't deny I'm in many ways a descendant of it in far too many ways. But also, what I want to see a trial. And I don't mean I need to see the trial on TV every day like O.J. Simpson. I want to see these issues battled out. I want to see them briefed. I want to see them thoroughly vetted. I want to see the position of the prosecution vetted. I want to see the position of defense vetted. I wanted to see some of these issues that are being raised that we've never seen before. Let's start putting them in the pipeline now to start getting decisions on them, because while we've never seen this before, we can't now erase the possibility that we won't see something like this again. And at the end, I at least want to be able to say, after seeing everything, no matter how it turns out, that I can look at it and say, okay, there was a fair process that took place. It was fairly done. There were judgments and rulings that were made, whether I agree with them or not, that were based on the law. And then I will have a lot more confidence as to where we as a nation stand. But if at the end it feels one way or the other that it didn't go that way, then that might start to get a little depressing.
Well said, Eric. This has been fun, you guys, and I appreciate everyone joining us. And Bob, thanks for jumping up on stage. Bez, you too. Jarrett, Ira, Eric, thank you for your time. Thank you for your expertise. Thank you for your thoughtful insight into, what's a historic day when it comes to the history of the United States. This has never happened before. And we'll see what happens moving forward. We'll see what facts come out as opposed to what pundits on the left or right think is going to happen. And I think Jarrett hit it right on the head. It comes down to transparency. The more transparency we have in these types of cases, ending up in a trial where the facts and evidence are put on the table and a jury of the defendant's peers come to a decision. I think that's the way this thing needs to play out.